expert reports are required as part of that, so most likely the board would be reaching out to experts on those different conditions and the use of medical marijuana to treat those, and then that would need to be available to the public if additional conditions are added.
Kim, your slide said that the affirmative defense is potentially there. Is it your position that potentially is in reference to an individual's specific situation, or that potentially that you're not taking a position whether the affirmative defense is or is not available?
The medical board has a statement on the website, and we would certainly encourage you to look at that for more detail.
Would there be any consideration for advanced practice providers and their role as recommenders?
At this time, House Bill 523 is limited to physicians holding an MD or a DO license, so a medical doctor or osteopathic medical doctor, and no other practitioners are able to recommend at this time by statute.
Follow-up question on that. I know you said MD or DO. How about providers from the UK system? They have like an MBBS who can get a medical license here? Is that are they going to be?
I believe that the license that they get here would be probably an MD license.
That's issued from the state. So you're
right. They have to be Ohio licensed physicians. Yes.
Anything else? I have one for Aaron. This is about boars. I'm curious in our research to date if we have had any discovery of the length of time it takes a state-based forest program to get these products loaded and actually traceable, and if that might be impacting our timeline.
So that is something that we're going to have to work out between pharmacy and commerce. I don't have an answer for that. Not every program that exists today, very few programs actually have their PNP built into their medical marijuana program.
Okay, thank you.
I have a follow-up question on that then. So how would reciprocity work if someone gets it from another state that wouldn't show up on our board report probably?
So that is something that we have not determined yet.
We good? Okay. So hopefully you're all aware. First of all, thank you for the presentations. I think we have a better idea of scope now, what the job is in front of us. Particularly those of us that represent boards, and we'll have to get on a pretty aggressive timeline. So thank you for that. It helps set the tone.
I'm sorry. Yeah. We do have just a handful more slides.
Oh, go ahead.
Sorry. A few other points that are worth noting that are kind of overarching. Of course, in the legislation, as we've discussed, the legislation does establish this esteemed body here today. 14 members of the Medical Marijuana Advisory Committee appointed by the governor and legislative leadership. The statute says directly that the committee may develop and submit to the state agencies any recommendations related to the medical marijuana control program and implementation and enforcement of Chapter 3796 of the Ohio Revised Code. So that is the charge that you have been that has been set before you, and that is why we're here today. We view this committee as a very important stop in our efforts to promote transparency and start the public input process. It's our opportunity to kind of tell our story and start getting feedback from others. A few other provisions that have been referenced that I think are worth noting. House Bill 523 is pretty strong on the employer side in retaining the employer's ability to make decisions related to employment as it relates to medical marijuana. So the legislation, the law, does not allow or it does not require an employer to permit or accommodate an employee's use, possession, or distribution of medical marijuana. It does not prohibit an employer from refusing to hire, discharge, disciplining, or otherwise taking an adverse employment action because of that person's use, possession, or distribution of medical marijuana. It does not prohibit an employer from establishing and enforcing a drug testing policy, a drug-free workplace policy, or a zero-tolerance drug policy. It does not interfere with federal restrictions on employment, and especially this is in reference to transportation requirements for those who may have commercial driver's licenses or requirements that they be drug-free in order to drive commercial vehicles. It does not permit a person to commence a cause of action against an employer for refusing to hire, discharge, disciplining, discriminating, retaliating, or otherwise taking an adverse employment action against a person with respect to higher tenure, terms, conditions, or privileges of employment related to medical marijuana. And it does not affect the authority of the administrator of the workers' compensation program to grant rebates or discounts on premium rates to employers that participate in a drug-free workplace program. So again, generally speaking, employers retain they may retain many of their current policies related to marijuana. Next, I wanted to touch on this issue of municipalities and townships. The law states that the legislative authority of a municipal corporation may adopt an ordinance, or a board of township trustees may adopt a resolution to prohibit or limit the number of cultivators, processors, or retail dispensaries licensed in this chapter within that municipality or township. It also states that municipalities or townships cannot adopt an ordinance or resolution limiting research related to medical marijuana conducted at a state university, academic medical center, or private research and development organization as part of a research protocol approved by an IRB or equivalent entity. And so I think this speaks a little bit to Dr. Stern's point earlier. We are seeing a lot of temporary ordinances passed to not include the industry in a city in particular. And we're seeing a lot of that. I think what I have learned is a lot of these municipalities and townships need to carefully consider their zoning laws and other policies related to whether or not they will welcome marijuana into the industry, into the community, and a lot of them are taking their time to do that. And I think we are taking our responsibility there to make sure they have the information they need to inform those decisions rather seriously. So, one slide on financial services. This is a topic you hear a lot about, and quite frankly, this is one reason why it's very good that we have the Department of Commerce working in this issue, because they also are quite involved with the banking industry. You hear a lot about the challenges of banking the medical marijuana industry, and a few words on that from the law. The Act does exempt from a financial institution that provides financial services to the medical marijuana industry from certain criminal laws if the business is in compliance with Chapter 3796. Of course, that does not impact the federal requirements that revolve around the banking industry, so I think that does remain a concern for some. Also, House Bill 523 authorizes the Department of Commerce to establish, they may establish a closed-loop medical marijuana payment processing system for use by patients and caregivers as well as the industry. And then finally, it's been mentioned several times before, but one more plug for medicalmarijuana.ohio.gov. This is our effort to be coordinated in making information available no matter what agency is putting it out. That's going to be the one-stop main stop for all of the information related to the program, including timelines and rules. And that's how we will also be taking input from the public right at this time, is through that website. So.
And a final stop for questions.
Sorry, I do have a comment and a question. First of all, my comment, that website, medicalmarijuana.ohio.gov, is excellent. As a practicing physician, literally daily, patients ask me about it, and I can direct them there. It's good. The question I have is regarding, the payment or the cost of medical marijuana, and since essentially there'll be these dispensaries, vetted by the state, almost like a monopoly. Like, how are costs going to be controlled in this? I mean, are there going to be price controls, or are the individuals that have a dispensary free to charge what they want?
The law is silent with regard to price control. I think it's a classic issue of supply and demand that we are acutely aware of. And so I think you see wide variances in price from state to state. And a lot of that is due to just the variances of different state laws and also this supply and demand fundamental issue.
My understanding is that the municipalities who have taken action have established temporary moratoriums just to get an understanding of what's taking place. Are you aware of any municipalities who have passed outright bans on dispensaries?
Not off the top of my head. I will add though, Johnstown has passed quite the opposite effort. They have gone on record to say that they welcome the industry. I know they are actively making plans to welcome it to their business park there. I feel like there was a debate over something more than a temporary moratorium, but I can't recall off the top of my head where it was.
Could you go into a little more detail about the proposed closed loop system?
I may ask Justin to do that. That is a, banking is a the legislature was very astute to identify it as an issue that is of concern. We have heard from other states that the industry dealing in all cash is a risk point. And however, I think we're starting to see the banking industry learned how to adapt. I think we're hopeful that will happen here in Ohio. But the closed loop system is envisioned to be a non-cash based system that can assist with the industry and patients with transactions. Is that fair?
From a local law enforcement perspective, how do you see us interplaying with enforcement, minors, diversions, that sort of thing, and the difference in states, because we don't have it now?
I think you have identified one of the reasons some municipalities and townships are carefully considering these moratoriums, because I believe that law enforcement is a piece of that in order to try to prepare for when the product is available. I think these are conversations that they need to be ongoing, but I think the most important thing that we can do is educate law enforcement on what is legal under House Bill 523 and what to look for from a diversion standpoint.
Local law enforcement, I'm sorry, go ahead, sir.
I would add to that, Ohio does not allow home grow, which a lot of people may be inclined to do since we have no control over the price if it is too expensive from a medical marijuana recommendation standpoint. So to the extent that we can work with law enforcement, local law enforcement, to cut down on home grow or individuals that are cultivating without a license, it will only make the program that much more successful. So I think there needs to be strong collaboration there.
But at the local level, as far as enforcement for the others, we're still going to use oars and that sort of thing?
Correct.
Just to clarify, these moratoriums do not limit patients' ability to utilize these treatment modalities. It only limits the ability for marijuana-related businesses to operate within those jurisdictions. So if there was indeed a moratorium in place, that would not keep patients from being able to utilize the medicine.
Thank you, that is correct. And although it does present access challenges depending on where you live.
Anything else from the committee? Okay. So one of the primary reasons that we exist and are called out in the legislation is to be the first stopping point for draft rules as the various boards begin to promulgate them and work through them, and provide our recommendations back to those work groups and those agencies as we work to implement this program. So in order to prepare us for that part of our work, I'm going to ask Aaron to take some time now to get us a little more up to speed on what the actual rulemaking process is, so that we're aware of what the flow is going to be, and we can help with our education efforts as well. So Aaron, if you can take that on.
Thank you.
Yeah, so Ohio does have an administrative rulemaking process in place for all rulemaking bodies in the state. Before I get to that, I do want to mention though that there's several public input opportunities. We are adding one at the beginning, before the rulemaking process even starts. So this committee here is really the first stop for all of the rules. So in addition to the feedback from the committee, medical marijuana control program agencies will provide interested parties the opportunity to allow input on rules as they're drafted and prior to their submission to the Common Sense Initiative, which I'll tell you more about in a coming slide. Opportunity for comment will be posted to the Ohio Medical Marijuana Control Program site. And again, that's medicalmarijuana.ohio.gov and then /rules. So the first step in the administrative rulemaking process is that the rules have to be filed with the Common Sense Initiative, commonly referred to as CSI. This gives entities that may be impacted by the rules an opportunity to provide comment. CSI
Sweet dreams are